Hello, everyone, and welcome to this Young Europeans Network webinar with Chris Benn, immigration lawyer from Seraphus. We're just waiting for some more people to join here on Zoom as well as on Facebook, and then we'll go through to some practicalities and the program for this evening. So, welcome everyone who's joining on Zoom. I see quite a few people on Zoom, and we're also live on the 3 Millions Facebook page and the 3 Million forum as well. So hello to the people on Facebook. Just waiting a couple more minutes. My name is Alexandra Bulat. I'm one of the co-chairs of the Young Europeans Network, which is the youth wing of the 3 Million. And every month we're doing a webinar live on Facebook as well and here on Zoom about different issues. So last December, perhaps some of you attended our webinar with Chris as well, who's here on the call today, about the EU settlement scheme, looking through some very practical questions about EU settlement scheme applications just before the end of transition. We did this webinar before the 31st of December. And now as we have finished this transition period and we are now after the 1st of January, we had quite a lot of questions from our supporters and people on the forum about what happens now, what happens after the 1st of January, what happens with people, with EU citizens who perhaps have family members who are still in the EU and want those family members to join them in the UK later on, and what happens as well to those who don't have family members in the UK but still want to come to the UK to study, to work, or for other reasons. So today we thought it would be nice to cover those two broad themes: family reunion and also the new points-based immigration system, just some basics for everyone to understand what's going on, because those systems can be quite confusing for everyone, for EU citizens in the UK. And then we also allocated a bit more time for Q&A with Chris, because last time we had so many questions. I think we had tens and tens of questions and we didn't manage to go through all the questions, although we did follow up with people. And today we'll have like a full hour of Q&A. So we'll have a presentation about those two main aspects from Chris, linking to some of the questions that you asked. We have again many questions submitted in advance through our Zoom registration form, and Chris will try to cover as many of those as possible in the presentation. But after that, if you have any other questions relating to the EU settlement scheme, to family union, to the new points-based immigration system, or anything that's related to immigration, you can try to get some of those questions through and answer them. So I see more people joining on Facebook as well. Hello everyone who joined a bit later. Just in terms of practicalities, what will happen this evening, I'll just speak in a minute about how to ask your questions and how to get the most out of the session, and hopefully some practical advice for you. But first of all, I would just outline the structure. So we'll have Lara, who you can see on the screen, who is the other co-chair of the Young Europeans Network. She'll give a brief overview about what we're campaigning on in the Young Europeans Network at the 3 million. If you haven't seen us on social media already or followed the 3 million before. And then we'll go to Chris's presentation, about 20 minutes or so, and then straight to the Q&A for the remainder of the 1 hour. So I think everyone who was supposed to be here joined already. So I'll just go briefly through the practicalities. A lot of you asked the questions when they registered on Zoom, and we had about, I don't know, I think 50 questions or so. Anyway, very many questions. And thank you to all who submitted the questions in advance. So if your question won't be addressed in the presentation or in the broader questions that we will address straight after the presentation, then there are two options for you to ask your question again here, and I will then read some of those questions to Chris, and then Chris will answer in the Q&A part of the session. So you have two chats here on Zoom. If you haven't been to webinars before, there's one general chat where Lara already posted an introduction message, and that's not for questions. So that's for your reflections, for sharing different resources, just for kind of general chat, as the name says. And then on Zoom, you also have an option at the bottom called Q&A, and that's the option that you have to use for the Q&A. So if you still feel you have questions, or if the presentation provoked additional question about your immigration status, you can use the Q&A function on Zoom to put your question, and then I'll be able to look at those and select as many as possible, hopefully go through all of them in the Q&A part. So that's it from the practicalities. There are a couple of volunteers from the Young Europeans Network who will be moderating the chat this evening, and will put different resources to different links and other kind of things. Yes, Maria asked in the chat, can I have a few questions if possible? Yes, sure, Maria, if you want to add the questions in the Q&A function, or if you don't find it, you can still put them in the chat and one of our volunteers will put them in the Q&A function. Then we'll go to the Q&A straight after Chris's presentation, so you will have the chance to answer your questions then. So yes, do use this Q&A function. Before we move on to the presentation, I would like to introduce Lara, who's the other co-chair of the Young Europeans Network, just to tell you a bit more about the campaigns we're doing very briefly before we go to the main topic of tonight, which is the immigration advice. So Lara, over to you.
Hi everyone, thank you very much for coming tonight. I'll just cover a little bit about who the Young Europeans are, what we do, and if you're interested, how you can join. So the Young Europeans Network are the youth wing of the 3 Million, an organization that has been campaigning on the rights of EU nationals in the UK since the result of the Brexit referendum. Since around last summer, we've been set up as a young organization. Our members are between the ages of 16 and 30. And we campaign on lots of issues that affect people our age and generally migrants in the UK. But generally, there are three big issues that we tend to focus on, which are the rights of EU students in the UK and how their access to education in the UK has changed since the referendum. And we launched our network with a campaign and a webinar on the rights of EU students in September. So if you have any questions about that, the website that's on the chat there will have a link to an FAQ on questions that came up from that webinar. We also have a really good, strong campaign on voting rights because we believe that migrants in the UK should have the right to vote in local elections. And that's something that we're really passionate about. And we want to make sure that as many EU nationals who can vote in the local elections of 2021 will vote. So we'll be encouraging people to register to vote, vote by post, and vote on the day as well. And following on from this election, we'll continue working on encouraging people to be involved in local politics and really using their voice to campaign on the issues that matter to them. And thirdly, something that we're starting more this year is a campaign on access to British citizenship. People like myself have been in the UK for quite a few years, but unfortunately, I'm not allowed to apply for British citizenship at the moment because of this curious little thing called comprehensive sickness insurance. So we consider that as a real barrier to citizenship for those that are interested in it. So our network of young Europeans, we've got a lot of volunteers and members who would be interested in becoming a British citizen. However, there are these bureaucratic barriers, but also there is a really strong barrier, that of the cost. The application fee is over £1,000, and that can put a lot of people off from applying. So those are all issues that we care about and affect us. And by coming together in this network, we of already over 50 volunteers, we can really work together on these issues that affect us. So I would invite anyone who's interested in campaigning on these issues and just meeting more like-minded young migrants, young Europeans, feel free to get in touch with us. We are also a very volunteer-led grassroots organization. So if there's any other topics that you care about, we can find a way to also work on that. But focusing on tonight, of course, the new immigration system will be something that will be affecting all EU nationals and all migrants in the UK, or those that plan to come to the UK in the future. We have already been seeing how some students will be affected by this. So Chris will do a great job today of covering some of that and answering the questions that have been submitted beforehand. But that's it from me. Just wanted to say that we do a lot. You may have seen us on social media doing videos. We've started a TikTok account as well. We're really trying to reach new audiences and spread our message. So I hope to see you more involved with us in the future. Take care.
Thank you very much, Lara. One thing before we go on to the main topic, which is the Q&A and the immigration advice this evening. I see a comment already on Facebook, and please feel free to ask your questions on Facebook as well, because I can see both the Zoom Q&A and the Facebook, so please feel free to comment in the Q&A part. Someone is asking about the physical proof of status and about, is it not time now to ask for physical proof of status? Well, the 3 million and many other organizations in the migration sector have been asking for physical proof of status for a very long time. We had the campaign, if you look up our social media, called Denied My Backup from months ago. We had letter writing campaigns and many different types of campaigns asking for physical proof of status. Unfortunately, at the moment, the government still doesn't accept that or doesn't engage necessarily with some of the arguments, but we're still campaigning on this, and I know others in the migration sector as well campaign for physical proof of status because I think it's really important. That's not something necessarily that the Young Europeans Network are focusing on, but definitely it is a 3 million campaign, so do follow. We post quite a lot of things around physical proof of status. We have a reporting tool as well in the 3 million if people experience issues with their digital immigration system. If you can check out our social media, you surely will find in the last 2 or 3 days a post about that campaign, so definitely it's something on the radar, and we can continue to campaign on that. So yes, do continue to ask your questions. It's not a campaigning type of webinar, but maybe at the end I can answer some campaigning questions, but we'll focus first on Chris and on the immigration Q&A. So Chris, over to you with your presentation, and then we'll jump to the Q&A session. Thank you.
Thanks, Alexandra and Lara, for the introduction, and thanks for everyone for joining. Can't see everyone, but it's nice to know that you're out there, and obviously we'll be trying to answer as many questions as I can do about anything that you've submitted about the settlement scheme, or indeed the new immigration system, and there's a few that are outside of the box of even those, and I'll try to give you my view if maybe not an expert answer. So one thing that I think I will do when I run through the presentation is I've had a lot of questions about pre-settled status and the absences rule for 6 months. I can see there's a trend of questions that are about that. So I'm going to leave that as a separate topic. I'll scoot through it when I go to the presentation. I'm going to come back to it and answer some questions on that, because I know how important it is for people, but it's also quite a complex issue. So I'll just do the main sort of the more straightforward side of the presentation first, which I'm hoping that everyone can now see. If you can't, then tell me, but it should be sharing right now.
Yes, it's all fine, thank you.
Cool, thank you. Okay, so let me just break up what we are going to be talking about here, because we're talking about two very distinct categories of EU citizens, and that is obviously because of the end of free movement law. And what that means is, from the 1st of January 2021, the UK operates its own domestic immigration laws, its own border controls outside of the European Union regime and the laws of the European Union. And what that means is, for someone who is not part of the settlement scheme, is that they are subject to these new visa conditions that apply to them depending on what they would want to come to the UK and do. And I'll come back to some of those visa routes in the second part of the presentation. Just as a general point about the new system is, visiting aside, the way the UK operates a visa system is you apply outside of the UK under the designated route, work, study, and then you're allowed to enter on that basis. If you're entering as a visitor, as an EU citizen, and as always, when I talk about EU citizens, I mean EEA citizens as well, so Norway, Iceland, and Liechtenstein, as well as Swiss citizens. So I'll use EEA or EU citizens, but I mean everyone in that group. And yeah, so essentially you're applying outside. If you're coming to visit, you don't need to do anything in advance. You can turn up at the border, come through the e-gates as a visitor. Let me talk about EU citizens who are eligible for the settlement scheme first. because actually the majority of the questions that I've received in advance are actually about the settlement scheme rather than the new system. So that's how I've decided to take this first. As we do all know, I'm sure it is the settlement scheme is a reflection of the obligations the UK has due to the withdrawal agreement with the EU, and that it covered any EU citizen resident by the end of the transition period, which was finished on the 31st of December 2020. There is a deadline of the 30th of June 2021 to apply for your EUSS status, either pre-settled or settled. Family members of EEA citizens who qualify for the settlement scheme, they can apply in the UK if they're already here, or they can apply to join their sponsor in the UK in the future at any time. So if your EU family member doesn't live here at the moment, they are eligible to join you. They don't have to apply by 30th of June 2021. That deadline is for people who are already living in the UK. So, I mean, very straightforward again. We're talking about, when we now talk about EU citizens and immigration, we have to make sure we distinguish between what category they fall under. Is it the settlement scheme, or are they EU citizens subject to the new immigration system, or sometimes it's called the points-based immigration system? That means the same thing. It means the post transition period from January the 1st, 2021. That is the new immigration system. Okay. So again, I've tried to take away sort of the really basic stuff here, because I think most people have a decent grasp of what goes on with the settlement scheme. Welcome to ask any questions about that as we go on. So settled status for those who've lived here 5 years at the time they apply, pre-settled status for those who have not lived here for 5 years at the point when they apply to the scheme. The deadline is the 30th of June 2021, and everyone who is here and wants to apply under the scheme should be doing their application by that date. It's very important. Pretty straightforward application process. 3 or 4 things that you have to go through with the application process. One is obviously prove who you are, nationality, identity, to make sure that you're an EU citizen. Prove how long you've been living in the UK, or show that you were living in the UK before 31st of December 2020 or by 31st of December 2020. Make a criminality declaration for anyone who's over 18. And if you are the family member who's not an EEA or Swiss or an EU citizen themselves, you need to prove a relationship, either a current relationship or a former relationship to an EU citizen. So you have an extra stage if you're trying to apply essentially as a family member. We have an online application process for the vast majority of people, supported by a phone scanning app to scan your passport or your national ID card if it has a chip that can be scanned. So that's the most straightforward way to apply. Some of the application routes are made on paper, and sometimes people have to call up the Home Office to request a paper application form, particularly if they don't have a valid identity document. I mean, this is something that we've been in a lot of discussions with other groups about at the moment, because people are struggling to renew their identity documents with their embassies because of COVID, because of the reduced services. And so if you cannot get your ID document renewed, then you will need to ask the Home Office to send you a paper application form. Then you can apply using the expired one if you can show them that you couldn't get a new document issued to you in time. Always important to remember who is covered by the scheme, and that's as a general rule, it's everyone from the EU, EEA or Swiss citizen. Those with permanent residence documents do need to apply. Even though they've already got their permanent residence document, they're supposed to apply to the scheme to effectively convert the permanent residence document. Non-European family members need to apply as well, even if they've already been issued with residence documents under the EU free movement law. If someone has indefinite leave to remain already, that's been granted to them under another category of the immigration rules, they don't have to apply, but we always recommend they do. Gives them digital status under the scheme, as well as it gives them beneficial rights under the settlement scheme that they wouldn't have under the indefinite leave to remain that they were previously granted. British citizens who've become European citizens cannot apply, but they can sponsor family members. in most situations. It does depend on how they became a British citizen. If you are Irish, you don't need to apply. You can, if you want, as an EU citizen, but you're not required to apply to live in the UK. And children must make their own applications, or you must make an application for children, unless they are British or Irish. So those are the people the scheme applies to. Family members is always something we get asked about, and a few questions came in about family members in the questions I was given beforehand. So family members obviously has a specific meaning. It covers spousal civil partner, it covers a durable partner, which I'll come back to in a second. It covers children and grandchildren. If they're under 21, then they're granted automatically. If they're over 21 years old, they have to show a dependency on the EU sponsor, and dependent grandparents or parents can be sponsored if they are dependent. There is a clause for some of those relationships, mainly the ones with when you're in a relationship with another person, and that is that the relationship must have existed by 31st of December 2020. So if you were married or entered a civil partnership on the 31st of December 2020, it is covered by the that relationship is covered. If you were married on the 1st of January 2021, in theory, that relationship is not covered by the settlement scheme. That there is another option to sponsor that person, but it's not under the scheme. And this is where it's important to understand the concept of durable partners, because what durable partner means is it means unmarried partner. If you're in a sort of serious relationship. Now, the Home Office considers relationships to be serious if you live with someone for more than 2 years or 2 years or more, or if you have children together. That's another example of a serious relationship. But it's important to know that it doesn't have a specific definition under European law, which is what the scheme is based on. And so if you can prove that you have a serious relationship that should be considered a durable relationship, then and that relationship was durable by 31st of December 2020, then that is supposed to be covered by the scheme. They are definitely more complicated applications for people to make. They are a bit tricky, particularly if you've been living together in the UK and you want to use that time together. So it's something that we get a lot of questions about, because it is more difficult to show the Home Office that you have a durable relationship than it is to show that you got married. Children, just to add to the children point, they can come to the UK anytime. It doesn't matter if their date of birth is after 31st of December. It doesn't matter if they're born in the UK or born abroad. They would still be covered by the withdrawal agreement and therefore the settlement scheme to be sponsored for status. When you do have a family member who needs to apply to the scheme, there's two things to think about. Or there's one thing to think about, but it divides people into two categories, and that is, did the family member live in the UK before 31st of December? Because if they did, if they've been living with you before that date, then they should apply to the scheme in the same way that the EU citizen is required to apply by 30th of June 2021. So that's if they've already were living with you in the UK before the end of the transition period. If they want to join you in the UK because they're not with you already, and it's obviously it is after the 1st of January 2021, then they have to apply to come to the UK under the scheme specifically, and then they join you in the UK under the scheme. But it's very important that they make the right application outside the UK before they travel in to the UK. So it's important to understand which family members fall into which categories. Just to say about those in category 2, which is those coming to join you in the UK, is that, as I've said, they have to apply it in advance. They cannot enter the UK as a visitor and then apply under the scheme, because EU citizens can obviously enter the UK visa-free as visitors at the moment. That's because that's the rules the Home Office has for visiting the UK. But you couldn't come here as a visitor and then say, oh, by the way, I have an EU sponsor who I'm married to and I want to stay under the scheme, because the Home Office will say, well, you entered as a visitor, so no, leave the UK and apply to come back in the proper way. So that's what would happen if someone tried to apply as a visitor. And there's essentially two ways of applying as a family member from outside the UK. You either apply directly for pre-settled or settled status, or you apply for an EU family permit. I won't go into the distinction there, but just to be aware there's two ways for that joining member to apply. I know it's already come up with Alexandra's answers about physical documents and so on, so I'm not going to go back through that territory. Of course, I would very much like people who would want a physical ID card to be issued with one, but at the moment that is unlikely to happen in spite of all of the very strong political campaigning that's been done on this issue. So it is very important that people know how to access the digital status, and that it is not the letter that the Home Office sends you when you're granted the status is not proof in itself that you hold pre-settled or settled status. You need to be able to get into that profile, which is done using the ID document you applied with, your date of birth, you enter it into the online portal, and then you get a code to your mobile phone or to an email address, which you use to log in securely. So, hopefully people are familiar with doing that, because it will become more important when we pass the end of the grace period. You can obviously update some of the details you have in your digital profile to keep it up to date, and things like ID. Your ID document can be updated in the profile when you change documents, so it's good to do it because it will save you having issues traveling through the border if your current document is linked to your status. But also things like your phone number, your email address, your home address, you can also manually update that. And then the other function of your status, of course, is to prove it to other people, is to prove that you have status under the scheme, and that you can do by generating the things that the Home Office calls share codes in the section of the digital profile that you then give to an employer or landlord, and they can then check your right to access work, to access renting property, to access benefits if you need to claim that, and probably in the future access NHS treatment. So that's how your digital status works. And as I say, we're in a period where certain people aren't allowed to ask you to prove your status. So an employer isn't allowed to force you to show them status, neither is a landlord. But you might find that people start asking for the status already. I know the 3 Million has a very useful tool where people can report issues with their digital status, and I would very much encourage people to do so, because the only way that these types of problems that people might have with accessing their status or accessing their rights, the only way that we can change that is if we know about it, and if it's something that happens to not just the person that you are, the person sitting next to you, if they're happening across the board, then we need that kind of information to build a picture of what's going on. So I would encourage, I'm sure we can share the link for that particular reporting tool. So settled status is indefinite status. It's for your permanent right to live here. You do not lose that status unless you're absent for more than 5 years. So that means you can leave the UK for up to 5 years without ever stepping foot on UK soil, and you wouldn't lose your status as long as you came back within those 5 years. Obviously, criminal offences can have your status taken away. And if you want to become British, you need to have that settled status first in order to be able to progress to citizenship. I know that there's already been a question and a comment about the health insurance issue. I'm happy to come back to that in the Q&A section. Pre-settled status, obviously that is for those who haven't lived here 5 years, so you're building up to your 5 years. And I did see one question that came in about when does my 5 years start, and it starts when you enter the UK. So it doesn't start when you're granted pre-settled status. If you're an EU citizen, that is, it's granted when you came into the UK. So if you came in 2017, and even if you got granted pre-settled status today, 2017 to 2022 is your qualifying period for settled status, and you can apply as soon as you tick over those 5 years, as long as you can show from your evidence when you entered the UK 5 years before you apply. So that's the way it works. I've said I'm going to come back to the continuous residence point because I think we've got lots of questions about that. So I need to be in the UK 6 months in each 12 months. So I'm going to come back to that because all these slides, as you can see, it's a complicated issue. These slides will explain that, and that's why we'll circulate those as well once I've talked about it. So that's covering the settlement scheme in a very quick and hopefully understandably concise way, just to talk about the new immigration system, because obviously that is part of what exists for people now, and so it's important to understand some things about it. There's no way that we could really cover in depth the whole system, because it has many different routes with many different conditions, but I'm going to just give an overview of the main things I think are important to understand about the scheme. And obviously, first and foremost, is who it applies to. It applies to EEA citizens who have not got any presence in the UK from before 31st or from by 31st of December 2020, unless they are those family members who are being sponsored to join. Of course, they are not subject to the new system. They are subject to the EU settlement scheme. But for everyone else, 1st of January 2021, new immigration system, and it covers visiting, it covers studying, working, it covers family reunion that isn't covered by the settlement scheme, and what I've called other niche categories, because as you see, I've got a list of some other niche areas of immigration law, just to give people an idea of what other routes are out there. Visiting is free. You don't have to apply for a visa. You can turn up at the UK border and you can enter through the e-gates. So there's no problem visiting broadly in the same way that someone would have visited the UK when free movement applied. It's very similar. But for non-visiting visas, you have a fee to pay usually, and again in most cases, and you have what's called the immigration health surcharge, which is a payment to the NHS for the duration of however long your visa is. Now, I've said students are sometimes exempt, which I'll come back to. Some visa routes lead to what we call settlement in the UK, so your right to be in the UK permanently. Some visa routes do not lead to settlement, and the Home Office would expect you to leave at the end of your visa unless you move into another category. Generally, EU citizens, this digitisation of the immigration system is carrying on under the new system for EU citizens, which means that you get an electronic visa. You don't get, again, you're not going to get a physical ID card to show your status. It's going to be an electronic status, a bit like a digital profile. So visiting, I'm just going to run through the main categories of visas now. So visiting, the way the UK operates is it allows people to visit for the UK for up to 6 months at a time without having to apply for a visa in advance, and they can grant you that 6 months on entry to the UK through the e-gates, or if you go through an immigration officer's desk, they will not stamp you. They should just grant you entry for the purpose of visiting. There is no right to work when you enter as a visitor, except for what they call some limited business activity. So if you were coming over to the UK for a meeting, because your European company has a office in the UK, you can do that as a visitor, but you're not expected to stay and work for long periods of time. What you also cannot do is you can't get to the end of your 6 months, leave the UK, and then re-enter a couple of days later and feel that you get granted another 6 months. That isn't what you're supposed to do, because what the Home Office or what someone at the border will essentially probably challenge you on is say, well, you've been here 6 months, you're coming back again, it looks like you're trying to live here by using visit visas, and then they may refuse you entry if you try to do that. So it's important that you don't try to, or no one uses visit visas as a way of living in the UK, because sooner or later they're going to get stopped. It is possible that someone at the border could ask you why you're coming into the UK, and in those situations, if you're coming in as a visitor, you would need to satisfy the officer that your travel is temporary and effectively, and that you're not here to do any of the prohibited activities. So if you were coming in as a visitor and the border officer said to you, what are you doing? And you said, well, actually someone's offered me a job, I'm coming here to work. Quite obviously, they're not going to allow you entry as a visitor because you're not coming in for that purpose. So just to be kind of clear on what you are able to do as a visitor. If you're coming, or if someone wanted to work in the UK, and they, as I said, and they're going to be applying for what's called now a skilled worker visa, and this is part of the UK government's policy to end free movement and to not allow people who they don't consider to be skilled enough to come and work in the UK labour market. So it has to be a skilled worker visa now, and what that means is having a job from a company who has a license to issue sponsorship. So the company has to apply to the Home Office for the ability to sponsor EU citizens to come and work in the UK. And it means that if you are someone who gets offered that job, is sponsored, you are coming to do that job. You cannot come in to do that job and then move into a different job unless you got sponsored in the job you wanted to move into. So you are tied to the employer, you are tied to the job that they tell the Home Office they're bringing you to the UK to do. And because it's skilled, the Home Office has set a minimum qualification standard for people to types of jobs that they expect people to be educated to a certain level to do. They also require people to prove that they have the relevant English language skills to come and work in the UK. And the job offer and the job that someone's coming to do has to be above the designated salary for that particular job. In most cases. So I've put in that bullet point underneath that there is something called tradable points. And what that means is there's a little bit of flexibility in the scheme. So if someone was coming to do what's called a shortage occupation, so a job that the UK really needs foreign workers to come and do because there's not enough home-based people to fill that job, it's called a shortage occupation. And what that means is that you can be paid lower than the standard rate that the Home Office expects to see because you're in that shortage occupation. So there's a little bit of flexibility. It's not huge amounts of flexibility, but there's something there. And basically, yeah, and just as a final point, people aren't allowed to enter the UK to look for jobs and then stay in the UK if you're offered one. You wouldn't be able to, like I say, enter as a visitor and then someone offers you a job here, just stay on and apply for the work visa. You have to leave and come back in that skills category. So that's a very quick overview of the skilled worker route. We obviously have the university and actually school studying. It doesn't have to be universities. When we talk about student visas, we often think of university studying, but it doesn't have to be. It can be younger people coming to school in the UK, and they can apply for a student visa to do that. What happens is the educational institute who they're going to study at, so the university in the UK issues that student a certificate of sponsorship. And then the student comes in for the length of the course that they're studying, undergraduate, master's, PhD, however long the course is, that's the length of the visa you're going to be applying for. There are, again, it's a visa fee, you have to pay that. And it's likely in most cases that overseas student fees will apply to that person. So very, very expensive compared to home student fees. It does depend on which nation of the UK you'd be studying in, because the devolved nations have different approaches to fees. So there's no way we could say this is the overall fee guidance. It does depend on where you would want to study. The immigration health surcharge is the payment to the NHS. Now, in theory, that will not apply to students who can produce a European health insurance card, because the trade agreement with the EU has agreed reciprocal healthcare. And that means that students who are covered by that reciprocal healthcare don't need, or they won't be required in the longer term to pay that fee. Unfortunately, at the moment, you have to pay the fee and then you're going to have to apply for a refund in the future, and not until 2022. So it's a very cumbersome process at the moment. I hope that that's something that might be straightened out and a bit more simplified in the future, but we'll see. At the end of a student visa, there is going to be what's called a graduate visa, which means that if you're studying undergraduate and above, you can stay in the UK for 2 or 3 years. The 3 years is for PhD students. And the idea is essentially you can work in that 2 or 3 years, and then perhaps if you get a job in a sponsored category and you wanted to stay, you'd be able to stay in the longer term. There is some options for short courses or English language courses where you can do it. You can undertake those as a visitor, but the key to that is that they are short courses. So any kind of university study for anything like longer than a term of study is going to be under the student visa route. And just to highlight about family reunion, because as I said, there's obviously the settlement scheme provides for family reunion, but that isn't always applicable, and certainly for someone under the new system it might not be applicable, and for some people who are covered by the settlement scheme, if their marriage took place after 31st of December, then they might not be able to rely on the family reunion under the scheme, so they have to look at different options. So basically, if you're applying under the student or skilled worker route and some other routes, you can bring your family with you if you have a spouse, civil partner, unmarried partner, or children under 18. You could bring them with you as your dependents. So then you are able to do that. You have to pay for individual visa fees for either of them, so it gets expensive for families, but it is an option. If you hold status under the settlement scheme and you cannot bring your family there to the UK under the settlement scheme because they don't meet one of the conditions or a number of the conditions, then what there is in the Home Office immigration rules is something called Appendix FM, which is the ability to sponsor some family members to come to join you. It is much more expensive versus the free the EU settlement scheme, and you have to be earning a certain level of money. Your partner has to show that they speak English. So it's definitely a lot more arduous to get a visa under that family reunion route. And so at the moment, every time anyone who has settlement status or settled status or pre-settled status or is eligible, anytime that if someone came to me and talked about family members, I want to try to get their family member under the EU settlement scheme family reunion before I looked at Appendix FM. But it might be something that ultimately you have to go to Appendix FM if you can't get them here under the settlement scheme. And British citizens who have a relationship with EU nationals will also, in most cases, be using Appendix FM. So those are the situations. Okay, just before I finish the new part and we move to the questions, there are some other slightly more obscure routes that are available to people in some situations. The health and care workers, if you're sponsored by the NHS or another type of provider who provides health services, they have a special visa category. Some companies can transfer employees and graduates into the UK. And then there's this route called T5, which covers the main one probably relevant for younger people, I would say, is what's called the government authorized exchange. And that is, they can be like internship programs or business exchange programs. There's a list of people who provide these, and it's available to people to come, and effectively it's sort of working experience, training experience. So it might be something that some young EU people will be using in the future. So just to say, there are some other routes, but really they're not. They're more they're a bit more niche than the first ones I talked about. So that, in a nutshell, is where we are looking at, or what we're looking at with the new visa system. So before I go to questions, I'm probably going to cover pre-settled status and the absences clauses, because I think that, like I say, I have had some questions about that, and I want to just be very clear. And then there's lots of questions in the Q&A box that I can see. So as far as, the pre-settled status rule to be continuously resident is, what that means is 6 months. You spend 6 months in the UK per year for 5 years to get through to settled status, which sounds straightforward until you kind of start to unpack what that actually means. So there's some people who said, how does the 6 month rule work? I had a question, how does it work? So basically, I mean, there's an obvious thing. Does it mean January to December is 12 months and I have to be here 6 months in that calendar year? The answer is no. The answer is no, but a question mark, because I can tell you, unfortunately, that the UK, the way they've written the settlement scheme rules is slightly different from the way that the European Union interprets that rule. And that makes life more complicated, because you have a conflict in the type, or what do you do to meet the conditions? Who's right, who's wrong? I think that's something that will be have to be decided a bit later on down the line. For the moment, the Home Office writes it in a certain way, where they say, we look at any 12-month period. So if you were absent for 3 months at the end of 1 year, one calendar year, and you're absent at the beginning of the next calendar year for 4 months, we would add those 2 periods of time together and say, no, it's 7 months, you've broken your residence, because it's within a 12-month period. So that's how the Home Office sees it. So they don't look at it between calendar years. So you always have to be aware, if you've had like a period of time outside the UK, when is your next period of time going to be? How close is it to that first period? Is it within those 12 months? Because if it's within those 12 months, the Home Office will add it together. And if it exceeds 6 months, then they will say you've broken your residence. So that's the sort of first thing to bear in mind about the 6-month rule. What we also have is in the rules for continuous residence is you have the ability to be outside the UK for an extended period of up to 12 months if you have an important reason for that. So it's one period of time within your 5 years of settled status, qualifying for settled status. You can have one period of time where you're outside for longer, up to 12 months in a single period. So it has to be for one continuous period if it's for an important reason. So traditionally, before anyone had ever heard of COVID, what that meant was if you were a student and you were at a UK university and then you went to an overseas university, you would be allowed to do your year or up to a year at your overseas university and then come back to the UK and carry on. That's what it sort of was there to design to do. Because of COVID, people are obviously saying, well, that's a reason why I've left the UK. I'm a student, I've been moved online, I cannot attend classes in the UK. So I'm working on my degree remotely. Am I allowed to be outside for more than 6 months? And the Home Office has a guidance document about COVID, and it says if you're a student who is remote learning, then we accept that is a reason to be outside for up to 12 months without breaking your continuous residence. So that's a good news as far as students are concerned. The same guidance says if you've moved outside and work remotely, your employer is in the UK, but you're working remotely for your employer, we don't consider that to be a good reason to be absent for more than or up to 12 months. So it's good for those in the student category, but it's not so good for those who've chosen to leave for other reasons, maybe related to family reasons. So it's not. I'd like to see that policy more generous towards what people have had to do because of the pandemic. But the point to think about there is, do not go over 12 months. If you go over 12 months, then there's no way back. You broke your residence because you've exceeded 12 months. It's only military service and if you work for the UK government that you can leave for more than 12 months. So that's basically that's what the continuous residence means. And just one final point on that is that if someone did break their continuous residence now, they cannot start another period, because everyone who is under the settlement scheme, who is not a family member who's being sponsored to join, so everyone who's the main applicant to the settlement scheme has to have a continuous residence that began by the 31st of December. So if you were in the UK and then you've been outside for 13 months and you break your continuous residence, because we've gone beyond the 31st of December, you couldn't come back in and continue building up residence for settled status, because you've broken the connection to your residence that began before the 31st of December. So you might not, if you've got pre-settled status in that situation, you won't necessarily lose your pre-settled status, but you won't be able to convert or apply for settled status in the future, because you've broken the connection to the residence that began before the 31st of December. And that's something I think that we will see, unfortunately. I can see it from the discussions I've had with citizens and some of the queries that we've received, is that some people will find that in the future they struggle to convert their status, which is very sad, and something which we're going to have to bear in mind when we think about future areas to campaign on, is whether that's something that's a fair thing to apply to people, and whether it's something that we would want to try to be vocal about, because I certainly wouldn't like to see people lose their right to qualify for settled status because they felt a need to protect their health by not being in the UK during the pandemic. I think most of us would probably take that position. So that's a bit on pre-settled status and qualifying. And I still have other questions. I know there's stuff in the Q&A box, so I don't know how you want to do this, Alexandra. Do we just keep soldering on, or do
Yeah,
you want
I
to pick
think.
out some questions to ask?
Yeah, I think that's great. I mean, I had a lot of information just to tell everyone that this session is recorded. So obviously it's on Facebook Live on the 3 Millions page and to be posted as well. So the link will still remain. So what I will do to everyone who registered on Zoom, even some of you who couldn't come for the whole session tonight, is I'll send a follow-up email to everyone who registered with the presentation slides if Chris wants to share them, and also with the recording. So even if, because sometimes I know that there you get a lot of information and sometimes you want to go back and double check something or double check what Chris said in a certain part of the presentation. So you have the access to the recording of the presentation as well as the slides. So maybe let's go through the questions. We have I think we have about 21 questions on here and about, I don't know, 6-7 others on Facebook. So I'll do that just a quick fire round like last EU settlement scheme session, if that's okay. I will
Sure,
maybe
absolutely. Yeah.
read some of the questions from here, and I will start with the easier ones and then we'll go
Thank
to
you.
the more complex ones by the end. Yes, there's a question that's quite interesting from Celine on Facebook. Let's start the Facebook question first. It says, "Good afternoon, I'm French and my 16-year-old daughter has dual nationality, French and British. She's been accepted at a UK school from September, and I want to move with her to the UK. How can I have the right to live and work in the UK, please? Could you direct me to the page I should apply on?" So basically, what should I apply for if my child move to the UK to study here, to be in school here?
Yeah, sure. So how old did you say the daughter was? Sorry.
16-year-old daughter starting school
16.
in the UK.
Okay, I'd have to check so I mean, if the child is over 18, then there isn't, you can't obviously bring a parent with you. You'd be considered to be independent from your parent. For child students, there is the ability for the parent to join in some situations whilst the child is undertaking education. But I'd have to look into what age the child is supposed to be in, and there's some additional conditions. So I couldn't definitively say, but that's the route that is potentially available, is to essentially my young child or younger child is studying in the UK, and therefore I would want to enter with them. It's a visa application, obviously. I mean, because this person doesn't seem that they have a connection to the UK from before 31st of December. But I would have to, as I say, I have to check the specifics of the age of the child is relevant, and there's some other factors. But that would be the visa route in that instance.
Yeah, so it's important. It's not the EU settlement scheme. So what we can do as well, if we have more details after the session, maybe Lara, one of the volunteers, could post on Facebook our email, the Young Europeans email. So if you could email us with the question, if we find more details, we could email you back with some more
Yeah.
information.
Sorry, I've also realised that she said the child was British. So in some instances, British children can sponsor parents if the British child is under 18. So there may be another avenue there. So again, it's one of those ones where you need to go and look at the specifics of the visa route. But it may be that the British nationality assists, but only because the child is under 18.
Yes, thank you for that. There's a short question from Alice here on the Zoom Q&A. If you have settled status and live the UK for a long period of time, how many days do you have to be in the UK when you visit in order to keep your settled status? So it's again like the clarification about how many days should you be in the UK to get the settled status.
Right, sorry, was that for settled status or for pre-settled status?
For settled status.
What was the name of the person who gave us the question?
Alice. I clicked it as answering live.
Oh, okay.
Yeah.
I can go into those ones.
Yeah, if you can see the answering live questions, I'm just clicking through all of those.
Okay, sorry. Maybe I can't see the specific question. So if I understand, so how many days to be in the UK to qualify for settled status, is that?
Yeah, so it's someone who has, so basically, oh, okay, I get what Alice means. So Alice has settled status, but she left the UK for a long period of time when she needs to come back to the UK to keep her settled status. So presumably Alice left because of COVID, but she already has settled status.
Oh, okay, yeah. So if you have settled status, then obviously you've got your you have a 5-year absences allowance. So long as you come back in within those 5 years for a brief, even if it's a brief period, you reset your 5-year allowance and then you can leave again. So if you got settled status, you get a long period up to 5 years to be outside the UK.
Okay, thank you for that. There's another one just in the other chat here. I think there was one on the same theme from Maria. Again, a clarification to what we already covered. But so Maria has been in the UK for a year, but she needed to return back to her home country. She already made the application for pre-settled status. If I want to stay, I want to ask if I stay longer than 1 year. So if she's away for longer than a year, will I lose my pre-settled status? So she has pre-settled status, but she is concerned about living more than a year in the UK.
Yeah. Okay. So again, that was what we were sort of covering in the part about pre-settled status. So if you've been granted that status, being absent for over 1 year, you won't lose it, because you would only lose it if you're away for more than 2 years, or as soon as you go over 2 years. So you'd keep the pre-settled status. But if you spend more than 1 year outside the UK, you will not be able to qualify for settled status in the future, because you've broken your connection to whatever residence that you had before 31st of December 2020, you've broken your connection to that residence. And so when you applied for settled status, they would say, well, you've been outside for too long. So you can run to the end of your 5 years of your pre-settled status, but you can't get settled status at the end of it. So anyone who wants to get settled status cannot be absent for more than 12 months at a maximum, unless they're on military service. Okay.
So maybe people are wondering what happens if you're on pre-settled status, you can't upgrade to the full settled status and you're on pre-settled status. What happens when your pre-settled status expires?
Well, at the moment, what would happen is that unless you applied into a different category, so you could apply potentially into one of those visa routes that I was running through in the new system, you might qualify for one of those routes, and if so, you can apply into that. But if you can't, the Home Office expects you to leave the UK because you don't have any lawful residence left. So
that's quite concerning if people don't realize their pre-settled status actually expires in 5 years.
It's phenomenally very concerning. Yeah, I agree, and that's why we want people to be aware of these rules. Because it's the difference between able to convert your pre-settled status to settled status and being asked to leave the UK. I mean, obviously, in the future, the Home Office may change some policies, but there's no indication right now that would be the case.
There's another question, another short question from V. I really like short questions. I am guessing that for new arrivals, they will not be allowed access to any public funds or homelessness assistance. So basically, will new arrivals be eligible for those public funds, homelessness assistance at all?
No, I mean, Vi is absolutely right. So under the new immigration system, which is the system that applied to non-Europeans when free movement existed, so it's being extended to EU citizens who are not connected to the settlement scheme. There's a rule that says that for most visas that says no recourse to public funds, and what that means is if you are on this visa, so if you're on a working visa in the UK, you're here to work, therefore you don't need access to public funds, and you have a ban from applying for those public funds, and that will apply to everyone who's granted. In the vast majority of the cases, that applies to everyone who's granted under the new visa system, irrespective of which visa it is that they've applied for.
Okay, so that's a clear answer to that.
Yeah, it's a no.
Okay, so next one, another short question from Philip. My wife's resident card is expiring in 1 month, and she already has settled status. Is she getting a new card, or does she need to swap for a new card?
Yeah, I mean, I'm assuming that obviously because she has a card, she's a non-European wife, and so the answer is she needs to apply for another card, a replacement card under the the EU settlement scheme. So she's that would probably be a card that's issued under European rules, and she can swap it for a settlement scheme card as well. So it should be for free. There's a Home Office webpage, which is quite hard to find, but you can make an application. You make an online application to swap it.
If any of the volunteers find the link, you can.
I can find it.
If not, we'll do the follow-up email with some more resources afterwards. There's another question from Avril here on Zoom. What absences out of the UK, what do you refer to by absences out of the UK? Are there exemptions like working abroad? I'm working abroad and it's not through a placement or job posting by a UK company. I'm not really sure what type of work there is, but yeah, maybe a bit more detail on what kind of work is considered exempt for those absences, what kind of work.
I mean, so the work that's considered that means that you're not considered to be absent even though you are, is what's called Crown Service. So that's working for the UK government. Basically, I mean, in the civil service is one way of looking at it, but you, if you work for the UK government, then you would want to investigate whether you'd be considered to be on Crown Service. If you don't work for the UK government, then you are not allowed. All of the time you're spending outside the UK is clocking up to those 6 months, irrespective of who you're working for. So it's only people who work on Crown Service who are exempted from the absences criteria.
There is an anonymous question here, which says, please guide us on the application for pre-settlement. I'm not really sure what you mean by this. Perhaps, I'm not sure if you mean like how do you upgrade to settled status, or
I think that's what they mean, upgrade.
Okay, so maybe like how will people upgrade from pre-settled to settled status? What do they need to do?
Okay, so I mean, you basically have to resubmit an entirely new application in the same way that you did for your pre-settled status. So same thing, scanning your identity document, filling out the information in the form, and then what you're doing, obviously, to convert or to change your pre-settled status to show that you qualify for settled status is that you would have to show 5 years of UK residence. So whenever you started being resident in the UK, if it's your national insurance number that shows that, then that's great. If not, then you need to have those documents to submit with your application to show the full 5 years of living here. So it's almost, you're doing exactly the same thing again as you did with your pre-settled status, but you will be, unless your national insurance number shows the 5 years, you will be asked to show 5 years of documentary evidence to prove that you've been living here.
Yeah, I think it's a very important point, because I still met some people who thought that it will automatically be upgraded. It's not. You need to have another application through the system.
It's a common misconception, I think, and an understandable one, but no, people have to reapply or make a new application.
On that same point, because I'm seeing that there are more on Facebook about this as well. I know you've covered this, Chris, but can you re-emphasize that or answer the question, if people have broken their pre-settled continuous residence, will they be able to reapply for pre-settled now?
Yeah, so the answer, and I probably haven't covered it in that specific way of putting it, but the answer is possibly, but only if that person broke their continuous residence before 31st of December. So let's say you were in the UK from let's say like in 2019 you were in the UK and you got your pre-settled status granted in October 2019. You then left for 13 months and came back in November 2020 and started living here again. So because you've been outside for 13 months, you've broken your continuous residence. So that grant of pre-settled status that you had from 2019, it's still with you, but you've broken the connection to the residence. But because you've come back to the UK before the 31st of December, you can apply for another grant of pre-settled status, and you can show that you were here before the end of the transition period for that second grant. So that in that case, you can get granted pre-settled status again, and you will need to be granted pre-settled status again to build up to settled status. But if you have the same type of situation, but if it was like, let's say you were granted you moved to the UK in 2019, you granted pre-settled status in 2019, and in December 2019 you left, and then you've come back in January 2021. In that scenario, you can't be granted pre-settled status again, because you've broken your continuous residence, which is the connection to your grant of pre-settled status in 2019. But you've had 13 months away, you've broken your connection, and you weren't back before 31st of December. So you cannot be granted pre-settled status again. You will not lose the status, the pre-settled status you already have, because they won't take it away unless you're out for more than 2 years. But when you come to the end of that pre-settled status, you cannot convert it or apply for settled status, because you haven't been resident before 31st of December 2020 when they look at it, because you broke the connection by coming back in January 2021.
Okay, thanks for explaining that. Again, I will take one from Zoom and one from Facebook, because I see coming as well. So one from Zoom now. I'm a British citizen. My wife is a Dutch citizen. We have lived and worked in Spain for 20 years. We want to return to the UK to live in the UK in August 2021. What is the process? Do we simply return and apply for the EU settlement scheme, or do we need to apply for anything beforehand? So presumably for the wife who is Dutch and coming with them in the UK.
Yeah. So they fall under a category of applications called Surinder Singh or qualifying British citizen, or potentially fall under this category, which is if you're a British person living in the EU and you want to come back to the UK with your non-UK family, in this case obviously someone who's from the EU, but who doesn't qualify under the scheme because they've not been living in the UK before 31st of December, so they don't qualify themselves as an EU citizen. But because the British person is coming back from the EU, under the scheme, they're called a Surinder Singh or a qualifying British citizen case, and they can sponsor their European family member to come with them, as long as they make the move back to the UK before March 2022. But that person who's coming with them has to apply for what's called an EUSS family permit. The EU citizen has to apply for that family permit outside the UK to come into the UK with that family permit. Because if not, they're going to enter as a visitor. And as I said earlier on, if you come in as a visitor and then you try and apply to the scheme once you're here, the Home Office says, no, you're here as a visitor. So you have to come in with that family permit first. So make the application. You hopefully will qualify because you've been living in the EU as a family. You're coming back before March 2022, but you have to apply to come back in the right way.
Thank you for that. I think there was a very, very similar question from Oliver as well. So I think that has been answered. But Oliver, if you have a follow-up question after that about this route, please do post an additional question after, because I think what you asked has been covered by Chris just now. One question, short question from Facebook now. Does pregnancy count as a valid reason to be out of the UK for the 12 months?
Yes. Yeah, it's listed in the rules as one of the valid reasons for being absent.
Okay, and there was some questions on Facebook as well about historic residence. So there are a couple that I see about does it matter when the 5 years of residency were? What if I lived in the UK from 1993 until 2000? Can I apply for settled status based on this historic residence?
Yeah. So in some cases you can, yes. So if you've lived in the UK for more than 5 years in the past, and you have not left the UK for more than 5 years, and by that I mean never been in the UK for one day within 5 years, then you can apply for settled status. Sorry, as long as you have been in the UK for one day at least within 5 years after you stop being a resident, you qualify for settled status. So your application consists of two parts. It's one, show the Home Office that you lived here for more than 5 years, at least 5 years in the past. And secondly, if you left more than 5 years ago, like in this case, I think you said 2010, then you have to show them that between 2010 and 2020, you at least came back each 5 years. So if you came back in 2013 and then came back again in 2016, you would be able to show them that you haven't broken your connection to those 5 years of qualifying. So yeah, so anyone with a historic period of residence that's more than 5 years, or at least 5 years or more, then look into applying to get yourself settled status, because you're entitled to it.
Okay, thank you for that. I'll try to cluster some questions because we have about like 20 minutes left from this session, and some people are asking about the questions sent in advance as well. So I'll just be honest, we got, I think, in total about 100 questions, mixing like the ones in advance with Facebook and with Zoom. So if you're going to answer every single one of those, we'll be here until midnight with Chris. So what we do after each webinar is that, you know, we have some volunteers who take note of all the questions which haven't been answered. So after each webinar, we'll try to get back to each of you with some links for some further guidance or some answers to your questions. It may take a bit of time, like usually we like have like a week or two until we get all those questions through, but it will happen. So like you'll have a follow-up on this as well.
Alexandra, why don't I just pick up on a few of those questions that came in that are not necessarily EUSS ones. I'll pick them up because I can probably deal with about 5 or 6 of them pretty quickly.
Yeah, that would be great. Yeah.
Okay, so I was asked the question about European driving licenses and continued use in the UK. Yeah, you can continue. You don't have to change your EU driving license to a UK driving license until you basically get to 70 years old. So you're fine to carry on driving on an EU license. Someone asked about a UK obtained qualification such as an architecture degree. Will it be recognised in an EU country? Unfortunately not at the moment, because the UK and the EU didn't agree in the trade agreement anything to do with recognising qualifications. They've left it open to try to negotiate something for the future, but at the moment, if you're not part of the withdrawal agreement recognition of qualifications, which you would have had to have applied already for that recognition, then it wouldn't be recognised today, just because you've got it in the UK, which is outside the EU. So unfortunately, a bit restrictive there. Someone asked about the restrictions of going to the EU. So I'm assuming this is a British citizen going to the EU, and they said, how does the 90 days and 180 days work? Because they have a property in Spain, but they're not resident there. So if basically the EU rules for Brit supplies is you're allowed access to the Schengen area visa-free for 90 days in each 180 days, but no more, without applying for an extended visa. So if you wanted to stay longer, you'd have to look at the country that you're going to see what their individual rules are. So it's quite restrictive for Brits. It's not the 6 months that the UK allows the EU citizens. The Schengen conditions are more strict than 90 days. So someone asked about double taxation of pensioners if they are residing in the EU. Again, I'm assuming this means a Brit receiving a pension in the EU. So there is a reciprocal tax arrangement or a tax agreement between the EU and between France and the UK, which covers dual taxation. So you'd have to look at the details of that. But mainly taxation agreements are outside the competency of the EU. If we're talking about direct income taxation, they don't really come under EU rules. So it's about whether the UK has individual agreements, which in the case of France, it does have an agreement to avoid people being double taxed, essentially. So that one, again, hopefully dealt with that quite quickly. And the last one I think I can deal with quite quickly was someone was asking about having their EU settlement status, the name of their status applied, given their married name rather than their maiden name, because in this case it's a French passport, but it's not just, this issue is not exclusive to France by any means. The French passport has the maiden name as the official name, and whether they can change the settled status or the EUSS status to the married name, which is the name that the person uses commonly, and of course lots of people would use their married names. The answer is at the moment no. And I know that they researched it and found that there was a parliamentary question about this, where there was an indication from the Home Office that they would look into allowing someone to use their married name and their status and their digital profile. But unfortunately, in spite of that promise by the Home Office to look into it, as far as I'm aware, they haven't done anything about it. It's still the same policy from the Home Office, which is we take the name that's in your passport, and that's the name we're going to give you on your status. So I'm sorry to say that there's not been a great deal of movement on that as far as I'm aware. Hopefully it's something that will be revisited. Okay, so that was just a few questions that we could get through quite quickly that came in advance. So hopefully people have heard the answer to the question they asked.
Yeah, it was a rapid fire round of of questions.
Yeah.
Yeah, I mean, I saw a very interesting one actually on the Q&A, because I actually don't know the answer to this either. I'll be very interested to know. There's what will happen to those people who actually came to work, started working in the UK in 2021, and they're not eligible to apply for the EU settlement scheme. Will they need to leave the UK on the 1st of July, even though if they have a job and a contract already? So they are talking about seasonal workers on a farm.
Yeah, so the answer is if someone basically, so someone subject to the new immigration system came in from the 1st of January and probably entered as a visitor, and then they got a job because the employer is told by the Home Office not to do anything except check the passport or the national ID card, so that person gets a job. It doesn't mean that that person has the right to work, because the conditions of entering as a visitor say that you don't have the right to work. It's just what's happened is the employer has not carried out the check that they were supposed to do, or that they've listened to the Home Office and haven't checked that person's eligibility. So the employer hasn't done anything wrong according to the Home Office, but the person who's got the job has done something wrong according to the Home Office, because they've come in as a visitor and they've broken the conditions of visiting by getting a job. So at some point, that person is probably someone's going to figure out that they don't have any status, and maybe not in that job that they got initially, because the Home Office says to employers, you don't need to retrospectively check for the right to work for these employees you take on in the grace period. So that's what they're saying at the moment. They're saying you don't need to go back and look at all these jobs that people have taken up in this period. But if that person tried to change their job, then they wouldn't be able to prove to a new employer that they had the right to work, and therefore the employer won't employ them. So it's not necessarily the case that on the 1st of July someone's going to come around and then the Home Office is going to come around and say, right, you have to leave your job and leave the country now, because they might not figure it out at that point. But at some point, this person would be run into a problem with someone, with the employer, with an NHS, with the landlord, and it would mean that they realised that they didn't have the right to work when they came in. Okay, so this is why it's very confusing, because people wouldn't necessarily know they were doing anything wrong, but they are doing something wrong by coming in as a visitor and then getting a job here.
Yeah, I think it may be quite confusing, especially if the system changed quite quickly. So there may be people who started work who are actually not aware of
Unfortunately, that's probably very true.
There's a question from Bianca which relates to the family reunion points earlier. So Bianca is hoping to have her mother come to the UK to look after her son for around a year and a half. What is the best route for my mom? She doesn't speak English. I'll have to apply for her. Is that possible to apply on behalf of someone? And what visa would her mother need to join her family member to take care of a child?
Yeah, okay. So I mean, there's no problem in the system in applying on someone's behalf. I mean, basically, when you apply from outside the UK for a UK visa, it's an application form that needs to be filled in with the details of the person who you want to get the visa for, or the family permit for. So someone can do that on their behalf. There's no interview process with UK visas in general. The issue is whether or not that parent would be considered to be what they, under the scheme, a dependent parent, because that's the criteria for someone who's got the status themselves. If they want to bring their parent to the UK, the parent has to be dependent on them according to the rules, which is according to the way that EU law works. So you couldn't necessarily say that someone wanting to bring their mother in to help them raise their child is a dependent parent. They might be a dependent parent, but dependency is usually about financial dependency on the person in the UK, providing money for that person to be supported, although there are other ways of being dependent. But if the mother, essentially, if the mother was self-sufficient in the country and had enough money to live off, then you wouldn't be able to say, oh, well, can I bring her in for a year and a half because I have status under the scheme, because she wouldn't meet the definition of being a dependent parent. So you need to look at the circumstances in that situation. I mean, the mother could come in for 6 months as a visitor to help, but she'd have to leave by the end of the 6 months. I mean, just one thing to say about dependency. At the moment, if you applied to sponsor a parent to come here to the UK, the dependency is what's called assumed by the Home Office. So they don't ask you for any evidence of the dependency. They just say, well, if you're applying for your parent now, between now and the 1st of July, if you make your application to bring your parent here, we won't ask you to prove the dependency. So it would be easier to bring your parent here right now than it will be from the 1st of July onwards, which some people might think very carefully about if they want to sponsor their parents.
Okay, thank you for that. I will take, I think, 3 more, and then we'll leave like a couple of minutes just to let everyone know where they can look for more support and like what happens to follow up with the questions that we haven't answered today. There's a few, like there's a cluster of questions around criminality and criminal convictions. So for instance, this one: what happens to someone who already has a status, has settled or pre-settled status, and breaks the law in the UK? Can they be removed from the UK based on criminality, and what happens basically people who have status and break the law, and what are the conditions or the top lines around that?
So the answer is that anyone who is granted status and then commits a criminal offence that they're convicted of will be looked at by the Home Office to determine whether or not they should have their status taken away. And the UK from the 1st of January will apply what they call UK deportation thresholds. So if the offence is committed after the 1st of January, it's the UK deportation thresholds that apply, not the EU thresholds. And then this is a little bit complicated, but basically in simplistic sense, it's easier for the Home Office to deport someone who commits an offence from the 1st of January because they have quite a low burden of a threshold. So if someone commits an offence, the Home Office will always consider them for deportation, and if they think they meet the criteria to be deported, they'll take their status away and they will remove them. That person would have an appeal against that because they could say, well, actually, you shouldn't be removing me because of the reasons that I put forward. But it will inevitably, there'll be probably a legal battle because the Home Office is very clear that they intend to remove foreign criminals from the UK if they commit offences here.
Okay, thanks for that. There's some questions around the benefits. So I'll take this one just because it's short, but we can get back to the people who ask the longer situation ones. Do you know anything about what's the difference between pre-settled and settled status when it comes to claiming benefits, especially housing benefits?
Yeah, I mean, okay, so the current situation is that someone with pre-settled status would have to show the whoever's issuing the housing benefit. Many benefits are issued by the DWP, some are issued by local authorities, but essentially the criteria is the same, irrespective. Is if it's a benefit that has what's called the right to reside test, which is you have to show that you were exercising a sort of economic free movement right to qualify for the benefit. So in general, this means you were working or you were self-employed before you made your benefit claim. And that's what applies to pre-settled status holders. That test doesn't apply to someone with settled status. They do not have to show that they were economically active. For some people on this call, they'll be aware that there was a court case about this particular issue of pre-settled status and benefits, which has been successful from the point of view that the Court of Appeal found the rule requiring the right to reside test to be met by pre-settled status holders was unlawful. So the legislation was unlawful. So the Court of Appeal has said that anyone with pre-settled status meets the right to reside test. So they only have to show that they qualify for the benefit, which is a really positive thing as far as accessing benefits when you have pre-settled status. The Court of Appeal decision is subject to an appeal to the Supreme Court. So it may not be the final decision. And whilst, at least for the time being, whilst there's still an appeal going on to the Supreme Court, the decision doesn't take effect. So the Home Office is, DWP or local authority is still allowed to apply the right to reside test as it stands today whilst this appeal is ongoing. That's what the situation is today. It will potentially change. It's being reviewed on the 26th of February, so there might be a change of position then. But at the moment, you wouldn't get any benefit from the case, but that's not to say you shouldn't apply. You should apply for the benefit if you have pre-settled status, but they won't make a decision on it necessarily until the court issue is resolved. So that's a bit of an update. So we're in a situation. We hope that either the case doesn't get to the Supreme Court or that the Supreme Court agrees with the Court of Appeal, but we'll see. We have to wait and see.
Okay, thank you for that, Chris. I'm just saving the most controversial question for the last, and then I'll explain what happens with the follow-up. And actually, I have like at 7 at a Young Europeans Network, our regular volunteer meeting. So if anyone who identifies as Young European on the call and wants to join the Young European Volunteers Network, Lara put the application form in the chat if you want to join our campaigns. So actually, there is a Guardian article that had a lot of impact in the past few days about EU citizens and voluntary returns. There are a few questions about that. People are a bit confused about EU citizens. So this question says, like, what are your thoughts about EU citizens being added to a policy giving financial support to those who want to leave the UK voluntarily? So I know there are like some mixed discussions about this on social media. So I was wondering what's the situation with that? If you can clarify, please.
Yeah, okay. So first, let me clarify what it is before I offer any view on it. So the Home Office, before the 1st of January, before free movement ended, the Home Office had a policy that applied to non-EU, non-European, non-Swiss citizens that said, in some cases, if you want to return to your home country, then we can provide assistance. We can potentially pay for your plane ticket. In some more difficult situations, we might pay for what they consider a reintegration grant of up to £2,000, which was much rarer. It's limited to generally asylum seekers and those who've been trafficked to the UK, although there are some other people who might qualify. So that's the position for non-Europeans, and basically the Home Office said from the 1st of January, because EU citizens, because of the end of free movement, are now part of our blanket immigration system, which applies equally, with the exception of the settlement scheme. Our immigration system now applies equally to EU and non-EU citizens in their mind. We are going to open up our voluntary assisted support program for those nationalities as well. So that's why the story is in the paper, because the Home Office has changed the policy. They haven't changed the policy, they've just opened it up to nationals from those countries. Now, of course, there is a perception, which you could say that whilst people are still applying to the EU settlement scheme, because we're in the grace period, they still have June to apply to the settlement scheme. Is it right to open up this kind of fund to encourage people to return back to their home countries, which is why people would be a bit upset about the timing of this particular policy, and I can certainly see where that comes from. So that's what it is. That's why it exists, is because it's bringing the policy for non-Europeans to the Europeans, but it happens to be open to people who are applying under the settlement scheme if they decided they didn't want to apply to the settlement scheme. So I think the important thing about any of this is we do not want to see anyone who is eligible to the settlement scheme, or anyone who wants to apply to the settlement scheme, be discouraged or in any way talked out of doing that by anyone, be it the Home Office, be it any kind of incentive to not apply, because they have the right to get their status under the scheme. So I think that's the key. I don't know to what extent people may take up the support offer or to go back if they do. We might not really get to hear too much about that. So, but that's to help people understand why it's there and why there's a story about it. But I think the key is no one should feel in any way pressurized to leave the UK if they have the right to apply to the settlement scheme or to get their status. This is their home if they want this to be their home. It would be my view on that.
Thank you very much, Chris, for that explanation. I think we did very well today. We answered 24 questions and we still have 20 questions to go, so it's much better than last time. And I think those sessions need to be like a whole day. Yeah, I'm really sorry, everyone, that we didn't manage to answer all the questions, but we actually have like this Young Europeans regular volunteer meeting now. And we will follow up with everyone. So you can either, we have a volunteer who collected all the questions which aren't answered, so it will take us a few days, usually like a week or so, to get a document together with all those anonymized questions answered. And then we actually will add some of the questions in an anonymized form to in our FAQ part on the 3 Millions website. So I think Lara already shared the link to the FAQ, and there is where you can find a lot of those questions actually covered, especially the more simple questions like how long can I be outside the UK, or can I apply for pre-settled status from outside the UK. All those kind of more simple cases are actually covered in our FAQ, so have a look at that. And if you still feel that you don't have enough information, you can send the question. I'm also aware there are a few of you who have like quite a long story question and like quite a complicated case, so I think in those kind of sessions it's quite difficult to answer to something that's quite complex, so maybe that's something we can follow up as well and at least provide you with some resources and links. Finally, before we end the session, Chris, would you like to perhaps recommend some places for people to seek more information, or anywhere they would get more advice, or any further sessions happening in the next weeks or so?
Yeah, I mean, okay, so I mean, in terms of if anyone needs assistance with their application, if they're struggling with their application, the Home Office has what's called the Settlement Resolution Centre. People will have mixed experiences, I'm sure, of maybe some long waiting times. But they, in theory, can help probably with the more technical aspects. I know that some people have raised with me some technical issues with applying, if the app doesn't work, if it locks you out. That's something for the Home Office to be made aware of. If you're looking for assistance with your application, Home Office does fund organisations, some charity organisations, community groups, some local authorities to help people, but in theory, it's for people who have a vulnerability. And also, I can tell you that I know that they're very stretched capacity-wise. They're doing a lot of work, and so I think that there's a concern that even though that funding is very welcome, it's not necessarily sufficient to cover the need. We do have on the website that I help run with the connection we have with the European Delegation, we have one called EU Rights, so just all one word, eurights.co.uk. I'll put it in there again, I'll open it up and I'll get it. So we do have a tool in there to look for organisations to help. Again, it might be a little bit wider than the Home Office list. We try to include organisations who help people for free in that list. And so there is some groups. Settled is obviously a very they're not Home Office funded, but they do a lot of good work with people. The 3 Million have some wonderful resources to help people look at their situation, and a lot of really good information there. And so I hope that all of it pulled together allows people to access something, or to help them talk to someone who can help them. And because I know how complicated some of these situations are, and some people really do need to speak to someone, perhaps in my kind of field, who really gets the complicated stuff. And then maybe some people have things that can just be resolved by calling the Home Office, and it does depend. But yeah, I just want, hopefully everyone feels that there is some support, and that people are going through the same thing as them, or have gone through the same thing, and so understand that it can be a bit of a challenge sometimes. I'll put the link to EU Rights in there.
Yes, if you can share the website. Yes, that's great. And yes, there are sources of support. As I said, do check our resources as well on the 3 Million and other websites, like on Seraphus website. Like, you can have a lot of the questions to actually find the answer online, but I also know that there are a lot of more complex cases, and we will follow up with those. I see a question just now. Can I join the 3 Million team? You can volunteer more broadly for the 3 Million. There's like a generic info inbox. If you want to email info@the3million.org.uk, we can put you in touch with the team depending on your interests. There are a lot of different volunteers in the 3 Million, and obviously we myself and Lara are the co-chairs of the Young Europeans Network, so there's a youth wing of the 3 Million. But even if don't identify as a Young European, there are other volunteer opportunities is for you. So do get in touch with our info inbox. So thank you again very much, Chris, and yes, Lara as well for the introductions. And yeah, have a good evening. Check the resources, and we'll be in touch with everyone with a follow-up email with the recording, the slides, and some further resources for you. So thanks for joining. Have a good evening.